Welcome everyone, and thanks for being with us today. My name is Danielle Lund, and I serve as Associate Director of Digital Engagement at the Alumnae Association of Mount Holyoke. Our work at the Alumnae Association is all about providing meaningful resources and opportunities for members of the Mount Holyoke community to connect. And on that note, I want to share with everyone that we recently launched a new platform called The Gates. I'm going to drop the link for that platform into the chat box right now. And this is a spot where you can forge connections with other members of the community. There's a career directory within that space, a discussion board, the opportunity to join affinity groups. So we encourage all alums to go ahead and check it out. We're going to be inviting all students into the space shortly. So getting back to today's event, if you feel comfortable doing so, you can feel free to go ahead and say a quick hello in the chat box found at the bottom of your Zoom window. Maybe you want to share your class year or affiliation to Mount Holyoke. We welcome you all to do that. For those who can't join live, we're recording the session and want to remind that no other recording is permitted. Again, should you have questions throughout the session, you can feel free to go ahead and drop those into the chat box. At the end of the session, if you want to raise your hand to vocalize a question, we can also take questions that way. So sharing with us today is Maria Faletti Jugin, an alum of the class of 1994, who's a seasoned human resources professional, to share with us on the topic of navigating HR. So Maria, without further ado, I'm going to now turn things over to you.
So thank you for the introduction. My name is Maria Faletti, and I am a graduate of the class of 1994. So that means, for the quick masters on the call here, that last year I celebrated my 25th reunion at Mount Holyoke. I was so fortunate to be able to get back to campus before the COVID drama ceased, all of those different things. So it was certainly a pleasure to be back. It was only the second time I had ever been back since I graduated. So it was a wonderful time and really helped me feel that reconnection to Mount Holyoke. So when this opportunity came up, I thought that I would jump in the pool and see if I could provide some knowledge about what I do for a living, which is human resources. And so I will go forward and tell you a little bit more about myself. My technical skills. Isn't Zoom wonderful? What did we do before Zoom? Let's see here. All right, next. There we go. So this is the official me. This is the me that the corporate world gets to look at this lovely picture. And this is all the good things about me that I talk about professionally. So when I was at Mount Holyoke, I studied sociology and African American studies. I then went on to get a master's degree in public policy at Georgia State University, and then became SPHR certified by the HRCI, which is a certification board for HR professionals. I've been working in HR for 23 years in a variety of disciplines, including leadership roles with outsourcing organizations such as Paychex and ADP. In all candor, I stepped back from doing full-time leadership in consulting. For any of you who have done that work, it is wonderful. You learn a lot, but it is grueling. And I made a mid-career decision to go back to what I really love, which is working directly with clients and businesses on their HR issues. So now I'm an individual contributor with a outsourcing organization called Insperity, the former Administaff, which I absolutely love. So in that capacity, I provide HR services to businesses ranging in size from 100 employees up to about 700 employees. So I work directly with a small group of clients on their HR. Outside of what I do professionally day to day, I'm a passionate volunteer with first generation college students. I have been working with an organization called College Bound Opportunities for many years, where we help kids in the Chicago area who come from families where they don't have any relatives that have ever gone to college, navigate that experience. And I am a proud Italian American living on the south side of Chicago, and very passionate about social justice issues that affect us here. So that's my professional bio. Here's the real story. Let's go to the next here. All right, so this is my real life. That's me and my husband, Scotty, at the top. That is us last year when we could travel. We usually travel every time around this year to Caribbean destinations mostly. Those are my 2 dogs, Dario and Maisie. My 7 cats are not pictured, and yes, I said 7. I am proof that the crazy lady can get married, because Scott's my 3rd husband. So hey, if a lady with 7 cats can find 3 different husbands, there's hope for everyone. I'm real passionate about my garden. That's me this summer. It was our biggest ever with COVID. I had more time on my hands to work with it. So I also, as you can see in these pictures, I am a fanatic of like all things. If you looked up what does a stereotypical Italian American woman look like, they'd probably have 10 pictures of me. I love my long lashes, acrylic nails, all that kind of stuff. And really right now it is grasping this work-life integration thing. Working from home constantly, not leaving the house as often as I would like to, et cetera, has really challenged that. So I do that all trying to balance like how much wine I drink. So if you don't want to talk to me after this about your HR issues and you have questions about any of these things, I am always happy to talk eyelashes. So back to the presentation now that you know a little bit more about me. So a lot of times people ask me, what even is HR? Most organizations have some kind of HR, and I would challenge you to say that every organization has HR. The question is whether they call it HR or not, or who do they allow to do HR? Because from a legal standpoint, and I should stop and say, I am not an attorney. I am a public policy expert, but I am not an attorney. So nothing I should say should be considered legal advice. That any organization, once you reach about 5 employees, I would argue that every organization that employs at least one person is governed by employment law, but 5 is really that point that there's no going back after that. So human resources is the application of the set of rules and regulations prescribed by state, federal, and local law, combined with a philosophy of a company. So when we look at things that are more the soft side of HR, or what has been called organizational development, those are things like a talent strategy, a recruiting strategy, a strategy on retention of employees, a strategy about how a business treats employees. But they're all, the undertone of that is all the public policy that tells employers how they can behave. And that's more of what we're going to focus on today. I do work on the other side of the fence, definitely. But with everything going on with COVID, it has really heightened people's need to understand their rights in the workplace. And so that's where we're going to lean today. But HR is really a combination of those two, compliance and the soft side of HR and human capital management. The discipline of HR, or HR as a career, has evolved from the personnel world. So if we were having this conversation in 1950, I may be a personnel manager. Those practices have their roots in the Industrial Revolution, because that's when it became most important for people to manage their employees. Pre-Industrial Revolution, if it was you and your family on a family farm, or maybe 3 or 4 families working on a piece of land, that was done individually, right? So who decided who did what work and who paid who was all decided individually, collectively. But as the Industrial Revolution progressed, there became a need for people to have these things more organized. The profession became further influenced by early labor laws of the 1930s, and really were enhanced by the Civil Rights Act of 1964, which we'll talk about later. So at the end of the day, Frances Perkins, when she became the early Secretary of Labor, she invented human resources, and there she is. She is really kind of the pioneer in my mind and a shining star for workers' rights, which is intrinsically linked to all things HR, even if it doesn't seem like it at your company. So why should you care about this? First of all, every worker in the United States has some fundamental rights, and most people don't understand them. In addition, the difference between state and federal law can often create additional confusion. If you are on any of the Mount Holyoke Facebook groups, of which I'm a member of many, and I've ever answered one of your questions, you'll notice that I almost always say, what state are you in? Because so many of these things are governed by state law that it can create confusion. So here's the big areas that we're going to touch on today. And so I have a couple of poll questions that I want to start with. My first one, Danielle, which is just a little bit to tell me about why you are here. What interests you in this topic? So if you could look at this pop up and vote on why were you interested in this? A great place to practice using Zoom in a safe space, right? I'll give everybody just a couple more seconds if you want to chime in. If not, we'll go on. But it looks like most people are interested for themselves. And the reason that I ask that is just simply to understand what everyone's looking for, because oftentimes people are, advocating for others that I work with and that sort of thing. So I just want to get an idea. So great. Thank you for that poll. So now I'm going to talk about a little bit, we can end the poll there, Danielle, and then talk a little bit more about the different areas we're going to cover, and then we'll have another poll. So the 4 key areas we're going to talk about today, and HR is a subject almost like tax. If I have any accountants on the line, we could talk all day about these different things. But the 4 we're going to talk about today are pay, benefits, time away from work, and EEO issues. So how are you paid? What benefits do you receive because you work where you work? What happens when you need to take time away from work? And then what if you're having an EEO issue? And EEO issues are things like discrimination, state statutes versus federal statutes, and what steps you can take if you believe you are possibly being discriminated against at work. So if I could have our second poll up, Danielle, let me know which of these you're most interested in, just to make sure that I give ample time to the items that people are the very most interested in. All right. Okay, very good. Well, I will make sure that I focus in on making sure that people understand their rights around EEO. And that is an area that people are extremely interested in, but it can also be a little bit confusing for people. So I will make sure that we spend a good amount of time there. Really, all of these laws, the pay laws are rooted in the IRS and the Department of Labor, but they all have roots out into the Civil Rights Act of 1964, which was amended in 1991, and then further amendments and additions to those laws. FMLA and ADA, which really can span into all of these categories, have grown from the 1990s forward, but because they are newer, they're the areas that I find my clients and the employees that work for them are the most confused about. Okay, so first let's talk a little bit about pay. Hourly versus salary, and as I'm talking, if you want to raise your hand so Danielle can unmute you or type a question in chat, please do so. I'm on a ton of Zoom calls, and I know that while I am absolutely captivating, it is a lot more interesting if we have questions and real life stories. So please feel free to jump in, interrupt, and ask a question. But these are some of the key questions I get around pay. So I'm going to go from the bottom kind of up. So frequency, how often an organization pays you as a W-2 employee. So notice in this case, I am talking about somebody who receives a W-2 from an organization, not a 1099 independent contractor. If you believe you're a 1099 independent contractor and you shouldn't be, contact me, find me on LinkedIn or Facebook, and we can have a conversation separately because there's a lot to unpack there as well. But if you are a W-2 employee, the state you work in governs how often your organization has to pay you. So if anybody's getting paid less often than once a month, it's probably not in line with the law. Once a month is the least frequently you can be paid typically, and that is only in a certain set of situations, typically reserved for salaried exempt employees, which we'll talk about in a minute, and typically only allowed in, again, states that say it's okay to do so. If you are an hourly employee, meaning, or non-exempt, meaning that you track your time either by a time clock or a time card or in some way like that, you're eligible for overtime pay. The majority of the states require at least every 21 days, with the lion's share requiring every 14 days. So what's important here to know, and what governs pay, is a dollar an hour paid for an hour's worked. So if you're in a situation, or family members in a situation where pay is being withheld as some kind of punishment or as some kind of bargaining card, that is unlikely not a lawful action, because if you've worked for a company, you must be paid for it, says the Department of Labor, and I'll give important websites at the end. So saying, for example, we won't pay you until you return your laptop, we won't pay you until you do this or that, technically is not within the confines of the law, as long as they're paying you on your regular schedule. So let's say you quit your job today and you're due to be paid Friday. They can tell you, you know, when you come pick up your last check, we want you to bring your laptop. That's fine. What they can't do is not give you your check because you don't on Friday. They can come after you in court for that laptop. It's not to say that you don't owe them back their property, but when you get into people holding pay as a punishment, that's where that should be a red flag for you, that that's not an acceptable pay practice. That helps us jump a little bit into exempt versus non-exempt, because we'll find that with roles where maybe you're using equipment or that sort of thing, and they'll say, well, if you don't return our equipment, we're not going to pay you. If you're a business owner, you may be on the other side of this fence saying, well, Maria, what do I do about my equipment? The really only lawful thing you can do, unless somebody has a contract, is reduce them down to minimum wage for their final paycheck. But you have to be paid at least minimum wage for every hour of work you do for a company. So just important to remember there. I'll talk a little bit about exempt versus non-exempt, which people often confuse with hourly and salary. Those things are cousins, but they're not interchangeable words. Exempt means exempt from the overtime law. You do work which exempts you from the law. A person is never exempt or non-exempt, the job is. So my job as a senior human resource specialist at Insperity is considered exempt, and that is because I am in the learned professional exemption category, meaning that the work that I do, the education and certification I have to have to do this job, puts me in a classification where they're allowed to pay me, that's where the difference is, salary versus hourly, and I am exempt from overtime. So I make the same amount of money every 2 weeks. Some weeks I work 30 hours, some weeks I work 50 hours, but I get paid the same no matter what. Non-exempt work means I am not exempt from the overtime law, and it means that I would have to be paid overtime for anything over 40. Now, could you have a non-exempt person that gets paid salary? Sure, and that's why these terms aren't interchangeable. You can be non-exempt and be paid the same every 2 weeks, or however often your organization pays, but you just have to make sure that you have a mechanism by which to report overtime so they could pay time and a half if they needed to. So that's why most non-exempt people are just paid hourly, so that it's easier to track the time and a half for anything over 40 hours in a week. I will say there are state exemptions to this, such as California. California has a different law for almost everything. So in California, it's in 8 hours in a day, not 40 days in a week. So that is really the overview on pay practice. I'll ask if anybody has a question about any of those pay practices before we move on to benefits. I will just take a brief pause and say that if you are being paid 1099 as a 1099 contractor, you should have a contract with that business on how you're going to be paid, what you're going to be paid, when you're going to be paid. Know that no insurances that business holds cover you. So that their workers' comp insurance, any liability insurances. The expectation is if you're an independent contractor that you would have those for yourself. So just be aware of that. It's not to say that 1099 or independent contractor work is bad or doesn't have a useful place. It does, but oftentimes it can be misused, frankly, to avoid paying taxes. And so if a business, if the IRS, for example, sees somebody has been getting a 1099 from an organization for 5 years in an amount that looks like an annual salary amount, that could be a tax red flag for both you and the organization to be audited. So just be aware of that if you've been a 1099 somewhere long term. Any questions before I move forward? All right. Well, we will go to benefits. Oh, I haven't been on camera this whole time here. I've been being nice and still and just not, let me show you my beautiful face and my eyelashes. Let's see here. Here I am in the library, everyone. Isn't that a fabulous background? If you haven't gotten your Mount Holyoke Zoom backgrounds, just Google Mount Holyoke Zoom backgrounds, and you too can be sitting in the library all the time, just like I am. So let's talk a little bit about benefits. Benefits are probably one of the most complicated parts of what I do because they are governed by a lot of different laws and they are only required in organizations that employ more than 50 people. The item that I would say I get the most questions about are really rights of continuation, so I'll touch on that. So the Affordable Care Act did require organizations with over 50 people to provide sufficient medical coverage to their employees. So just a few tips about medical, dental, vision. One reason you want to take it from your employer, if it's offered, is that you will most likely be able to pay for it on a pre-tax basis. So the monies that come out of your check are reduced on your taxable income, which could mean a better return for you at the end of the year. The other reason is that those plans are governed by law, so they sort of have to let you in. When you're, I'm a 2-time cancer survivor. When I came to Insperity, they have a group health plan. They couldn't ask me questions about my health. That's not legal. I have to be allowed into that plan during my open enrollment timeframe when I join the company. And then every year when they have open enrollment, I have to be given the opportunity to change it. So for me, as someone with very serious pre-existing conditions, along with a host of others, unfortunately, it's really important for me to have employer-sponsored health coverage where I know that I'm protected to be able to join that plan freely and change that plan as I need to during the open enrollment period. Another question I get asked a lot about enrollment periods is, what if I wanted to change my benefits? So benefits changes are ruled by what's called a qualifying event, and you can look on the DOL or IRS. Both of them have what a qualifying event is, but they are things like marriage, divorce, death, adoption, change in coverage. So if I was on my husband's insurance, for example, and he got fired, that would be a loss of coverage for me. So it would be a qualifying event for me to get he and I on my insurance. But you only have a short window to do that. It's between 30 and 45 days, depending on your plan. So if you know that you're going to have a qualifying event, talk to your HR department or talk to someone at your company and say, I'm going to have a qualifying event. I'm going to need to change my benefits. I don't want to miss the time window, because it's not up to someone else to tell you about that, right? You know that you're going to have a qualifying event, so it becomes the burdens on you to get the information needed. But that is your right, and it technically can't be denied to you. I'm just looking, okay, sorry, just was looking, I thought there was a question there. Okay, Danielle, I'm going to trust you that if there's a question I need to answer, you're going to let me know. How's that sound?
Yes, indeed.
Okay, so the other question that I get regularly is about COBRA and what does that mean? So COBRA is the ability to continue your benefits past the date that you lose them. So when you leave a company, anytime you lose benefits for whatever reason, I mean, if they fired you for an egregious problem, you know, you stole something from a company, you're still going to have COBRA rights. So COBRA means that you can continue your benefits, but instead of getting the benefit of what your company pays and what you put in, now you're paying everything. So it costs a lot of money. There's an election time period that you have. So you have so many days to elect COBRA, then you have so many days to make your first payment. So the people that typically use COBRA are ones that either A, feel like they're going to have a lapse in their job. They don't have a new job before they're leaving their current one, or they have health issues where they want to create kind of a gap to make sure that there's no issue with coverage. So say you were starting a job where the insurance didn't start for 30 days, you can COBRA for 30 days and then start your new insurance. I won't spend a lot of time here. It's pretty complicated and not really a fun topic for an hour webinar, but I will say this: if you're in a small employer and they tell you we don't have to do COBRA because we don't have 20 people, check your state regulations. Most states have enacted their own COBRA regulations, which requires them to offer some type of continuation via what's called state continuation, which isn't maybe as long as federal continuation or doesn't have the same benefits, but it does allow you to do some COBRA, during that time. The last thing I'll talk about quickly is other benefits. So oftentimes when you are enrolling, you have a new company, they have all this benefit stuff they're putting in front of you. There's all these supplemental coverages. I just really encourage people to look closely at those and see what they offer you. A lot of times you can really get better benefits than you could get on the street because they're being offered to you through your employer. So things like life insurance, accidental death insurance. I will tell you a story. My husband had an accident. He fell and hit his head at work. It didn't end up being a workers' comp injury. That's a whole nother story, and one best over one of my coveted glasses of wine. But I had signed him up for every extra benefit they offered. And we ended up collecting about $20,000 in insurance payments from an accident plan that, I had him on. Things like short-term disability, if your company doesn't offer it, but that you can supplementally buy it, just make sure you're aware of those things. I think sometimes people skip them over because they don't understand them. If you're getting a new job, talk to me, talk to another Mount Holyoke person that's in HR and let us explain what they are to you, because they can be really beneficial. All right, on to time away. So time away from work there's a couple of items that I would say are the sort of hallmark here. So first of all, holidays. Paid holidays are not the law. Giving you off holidays is not the law. So that is a benefit that a company provides you. Now, most companies nowadays are offering basic level benefits, right? So days like 4th of July, Christmas, New Year's Day, Thanksgiving, companies are offering off. Additional holidays that have come into vogue, like the day after Thanksgiving has become very popular. Christmas Eve has become more popular. And now we're seeing organizations strive for diversity and offering other holidays like Martin Luther King Day. And I even had clients add Juneteenth this year. But just know that all of those are not governed by law. You getting holiday pay is based on company policy. So just be aware of that. The same with vacation and any kind of PTO. Vacation time, time away from work, is not legislated unless you're in a state that legislates sick time. So if you're not sure if you're in a state that legislates sick time, again, talk to an HR person, your HR person at work, ask me. But many, many states and localities are now requiring sick time. So if you work anywhere in California, you have sick time that's required to be given to you. If you work in Maryland, if you work in Cook County, Illinois, or the city of Chicago. So these laws go as far as state laws all the way down to counties and municipalities. So please make sure that if you're needing to be away from work because you're sick, make sure that you're understanding your rights and that you're talking to somebody that can really help you understand what is my right as an employee who needs to take time away for their own illness. And that leads us into the FMLA and the ADA. And this is an area that I get a ton of questions on. And so other than the EEO, which I'll spend the most of my time on, I'll pause here. So the FMLA is the Family Medical Leave Act, and the ADA is the Americans with Disabilities Act. And these are the laws that protect you when you need to be away from work due to your own illness, or in the case of the FMLA, illness of a spouse, domestic partner, or child, and child could be foster or adopted. The FMLA is a law that gives people time to be away from work to handle those items. First myth that I want to bust around the FMLA is about FMLA pay. There is no such thing as FMLA pay. It does not exist. No one in the history of the world has ever received FMLA pay. Now, someone on this webinar or some say, yeah, I was on FMLA and I got paid. You very well might have, but the pay doesn't come out of FMLA. The pay comes out of either maybe your vacation, sick, personal time that you banked, or your company may offer a different kind of leave. I have clients that offer maternity and paternity benefits. I have clients that have very robust short-term disability policies that sometimes pay up to your whole paycheck while you're out on leave. But those items are being paid by those plans, not by FMLA. So that's just a confusion point that a lot of people have. FMLA is completely job protection. It is about the fact that if I go out, so if I go to my cardiologist on Monday, which I am, everybody wish me luck, and she tells me that I need to be out of work for 2 weeks because I have to have a procedure, I would go back to my employer, tell them that I need to be out for 2 weeks. They would give me FMLA paperwork. I would complete that. My doctor would complete her portion. And then I would have a conversation with them about how I'm going to be paid during that 2-week period. Most short-term disability policies, although not all, do have a waiting period. So at my company, it's 5 days. So for 5 days, I would be waiting for my short-term disability to kick in. So I would use 5 days of my flexible time off because that's what my company offers. And then my short-term disability would kick in. The issue is because of FMLA, when I returned after that 2 weeks, they couldn't say to me, well, Maria, you know, while you were out for 2 weeks, we realized we have plenty of HR specialists and we don't really need you anymore. So you can just go ahead and pack up your things and, you know, we're going to have you move on because we realize we can parse out your work to other people. That would not be lawful. If I was out on FMLA, I have a right to return to the same or extraordinarily similar position. So if you have ever been in a situation where you felt like you weren't afforded those rights, that's something you may need to look into. This typically applies to businesses with 50 or more employees. And so that's one reason that I also want to talk about the ADA. The ADA is another protection for people who have some kind of disability that affects them at work. And that would be governed by it's really for all employees. If you read the letter of the statute, it says 15 or more, but there's been court cases where that's been contested. So, I mean, ADA generally covers most American workers. And how the ADA differs is it says that the employers must engage in a conversation about reasonable accommodation with their employees. So let's pretend I worked in an organization with 20 people instead of one with 50. So FMLA doesn't technically cover me, but I went and said, I need an accommodation of 2 weeks off because my cardiologist has recommended I do so because of my heart condition. The role of the company is to engage in the interactive process with me. So they're not required just to say, yes, okay, Maria, you can be off for 2 weeks, but they are required to engage in the interactive process. Are you sure you need the whole 2 weeks, Maria? Can you work from home at all during those 2 weeks, Maria? Is there any flexibility you can provide, Maria? Now, if the answer is nope, I have to be out the whole 2 weeks. I have my doctor's paperwork here that says that. What I need is 2 weeks off. If the 20-person company were to say no to me and say, if you can't be here for these 2 weeks, we're going to have to terminate your employment, the burden of proof would be on them to prove that having me away for 2 weeks would be a matter of significance to their business, that it would have such a significant impact for little old me to be gone for 2 weeks, that they feel like they could not run their business and therefore they are going to deny me going away for 2 weeks and coming back. I got to tell you, it's pretty tough for any business to say that one person being gone for 2 weeks is going to crumble their whole business. If so, they need to look at their business model. So that's where ADA comes in and protects people that don't work in a place where they have FMLA. Now, don't get me wrong, FMLA does not take the place of ADA in larger companies. They exist in both places. I'm only speaking to ADA here as it relates to time away from work. ADA can cover anything from I need a special parking place to I need a different chair to I need to be able to go to a doctor's appointment every week for 2 hours to I need an air purifier at my desk. I mean, there could be a million different things that could fall under the ADA. The thing to take away here, and again, anybody feel free to contact me if you have an individual situation, but the thing to remember here is it's your employer's responsibility to engage in the interactive process with you. So if you take away one little, if you're anything like me on these webinars and you're half paying attention and multitasking, take this 1 point away. If you ever need to talk to your employer about the ADA, use the words, I want to engage in the interactive process with you. I'm interested in keeping my job. I value my job. I need this accommodation, and I really want to engage in the interactive process with you. That will be a signal to them if they ask their attorney that you know what you're talking about and that you're aware of it. If any of you on this call are business owners, what I would challenge you is engage in the interactive process. Show your people that if you're hearing somebody make a request to you and you're thinking, there is no way in HE double hockey sticks that I am going to do this for this person. Don't say that to them, first of all. Don't deny them off the bat. Engage in the interactive process. So say, yes, I understand that you would like me to install this $10,000 desk apparatus for you. Unfortunately, that's not in our budget, but I would really like to work with you to look at alternatives. That's engaging in the interactive process. So complicated issue, but wanted to make sure to introduce it here. Any other questions on time away from work? All right, I can't, yes.
I was just gonna say, I think we're good at the moment.
Okay, I can't let this topic go by without talking about the FFCRA and COVID being away from work. I'm sure someone on the on the line has had something involved with that. It was just extended through the end of this quarter. So the FFCRA was an emergency action to allow for paid time off if you have if you have COVID, if you're caring for someone with COVID, or if your child care or school is closed due to COVID. So those are rights for employers. The law is for employers with 500 or less employees. Many larger employers are using the tenets of the law anyway. It's good for them because there's a tax break for them on any of those hours paid. But just know you do have rights separate from FMLA and ADA when it comes to COVID. So if you're in that situation, make sure you're seeking out good advice about how those programs work. All right, so lastly, we'll go to the most juicy topic and the one that unfortunately I spend a lot of time on because it is truly running rampant in the United States organizations. So Equal Employment Opportunity Commission is the EEOC, and they govern discrimination issues in the workplace. And so the first thing to know is that if you believe you're being discriminated against at work, there are a few points you need to know. First of all, there's the state statutes, federal and local statutes. So just like with pay and things like time off, there are statutes across both state and federal and local guidelines. So make sure that you're aware. However, core rights fall in line for gender, age, race, religion, national origin, and thankfully, most recently, sexual orientation. That is only very recent that that's covered federally. And so the larger issues are federal items, but then there are also many, especially in California, that are at the state level. So the first question I would say is understand your state and federal regulations because they can be different. So the state is kind of the base, or the federal is kind of the baseline, and then the states tend to add to it. Secondly, keep documentation about the effect of those matters on matters of significance. So unfortunately, and I think we can all attest to this, being mean in the workplace is not illegal. I wish it were. I think at times it borders on slander or libel or bullying, which can fall into a harassment claim. But it's not the same as an EEO charge. So an EEO situation is one where, you know, let's say there's 10 people up for a promotion, you're a woman, and you are told that, you know, we went with Joe because, you know, Joe has a family and he is, you know, he's the breadwinner and we really just felt like he needed it. I mean, you guys were neck and neck, but he really needed that. I would love to tell you that doesn't happen anymore. It happens every day. Another gender would be, you know, we really liked we thought your presentation, you and Joe both really did a great job. The thing is, you know, you just got married, you're in your early 30s. We know you and Scott want to have a baby. The partners just really felt like Joe was going to be a little bit more stable. That's just gender discrimination, plain and simple. But the key there is that it's about me getting a job. Do I think it's right for my boss to comment on my fertility and that sort of thing in casual conversation? No, I don't think it's right. I think it's horrible. But it becomes an EEO matter when I didn't get a job, I didn't get a promotion, I didn't get that raise because of it. Now, sometimes people are just as blunt to tell you that. Unfortunately, team, I will tell you, people are ridiculous with what they will say. I mean, I have had people say things to me that you would just never believe someone would say out in the open, but they did. I'll tell you a little story. I worked at ADP, the largest human capital management payroll processor in the world. And they had a class action lawsuit where the person won because they assigned sales territories based on race. And I mean, they really thought they were doing a great thing. They, they said to, and it was in Chicago, they said to this woman, we're going to give you the South Side because, with you being Black, you're just definitely going to do better down there. And, that's the, we just feel like you're the best suited for that. And if we sent a white person in there, we just don't think they would do as well. Well, for anybody that knows Chicago, sorry, not quite as many Fortune 500 businesses on the south side of Chicago buying payroll services as there are as if I were given the downtown Chicago territory. So how easy is it going to be for me to make my goals if I'm given basically residential, non-industrial areas as my territory and told it's because I'm Black? But again, it isn't always a situation where it's that black and white, unfortunately. So if it's not, I would take careful notes, time and date stamped, and you can just do that with a notebook or sending yourself emails saying, I was in this meeting, this is what occurred, this is what the person said or did, date, signed Maria Jugin, and keep a record of those things, because that's what's going to make a difference. What the EEOC looks for is pervasiveness of behavior. So often, if you go to the EEOC and with one instance of something, unless it's a very obvious thing, like I was told I got this because of my race or my religion or my origin, if you're trying to kind of build up a case for yourself, you need to have documented instances of where it appears to be discriminatory so that can be investigated. So steps to take, and then I'm going to jump into another category because we had a question. The best thing to do is file a claim with the EEOC. You can do that online now. You don't need to go to the EEOC anymore like in the old days, and they will take your claim. You don't need a lawyer. You don't need anyone to represent you. You just make a claim against the organization that you deem discriminated against you, and it will start the process. What the EEOC then does is they investigate it and determine whether or not they found an instance of discrimination. If you do get a judgment from the EEOC that says, yes, there was a possible evidence of discrimination, that's where the choice comes of, do I negotiate with either my employer or my former employer, or do I seek counsel? Because once you have a letter from the EEOC saying, yes, this was discriminatory, it becomes a lot easier to go find a lawyer to work for you, especially if you don't have an upfront retainer, than if you didn't have that. But that's the way that the EEOC, takes in cases. It's a very simple process. The most common thing that the EEOC receives cases on is sexual harassment or harassment claims. And when you're talking about being harassed at work, there's really two kinds of harassment that happens. First is called quid pro quo, this for that. And it is meaning you're trading one thing for another. If you go out on a date with me, I'll give you the better shift at work. If you don't sleep with me, I'm going to make sure you don't get that promotion. Or even it can be more subtle, saying, Maria, you and Joe are both up for the promotion. You and I could talk about over dinner tonight why you feel like you're the best person for the job. And if my Zoom just went out, I know you can all still hear me. I was afraid of that because we're having some weather, so I called in on my phone. In any case, what I was saying is that so quid pro quo, this for that, a clear trade for something, right? The next thing that may come up in a harassment situation is a less obvious, possibly, called a hostile work environment. And hostile work environment is like one of those phrases that I don't know if there's anybody in my age range in here. When I started watching ER, the medical TV show, right, I learned all these amazing medical terms like CBC, Chem 7, stat, type and cross for 8. I don't know what those things mean, but I say them because I heard Dr. Ross say them. And, you know, it made me feel like I know what those are. And I you know, over time, it's like we become armchair doctors, right? Because we watch so many of these things. That's kind of the same of what has happened with hostile work environment. So a work environment that you don't like or that sometimes seems unfair may not also be hostile, unfortunately. So a hostile work environment is an environment where your work environment, due to harassment situation, is made so uncomfortable that it is deemed as hostile. And so an example of that would be, I go to work every day and there's two people in the cubes across from me, and they make racial and sexual jokes to each other all day long. I've asked them to stop, they don't stop. And so now I go to work, I'm nervous, I'm anxious, because I have to sit there and listen to them all day long, and it's very uncomfortable. A hostile work environment could be, I have a coworker who constantly asks me out on dates, or is asking me to go out for drinks, and I've told her that I'm not interested, but she continues to do it constantly anyway. And she never touches me. She never alludes to, she's not my boss, so there's not that quid pro quo. But every day when I come in, now I'm nervous, I'm avoiding her. I don't go in the break room anymore. I eat my lunch at my desk because I'm nervous that I'm going to be harassed, or that, you know, she's not going to leave me alone. That could be considered a hostile work environment. Unfortunately, like all of our medical terms or some of our legal terms that maybe we've picked up on television, employees have picked up the term hostile work environment as well. So they will throw it around if you're an employer yourself and say, oh, well, that's a hostile work environment. I always say being made to work Saturdays is not a hostile work environment. It's just annoying if you work in a job where you have to work every Saturday, or if it's a rotation and it's your Saturday. It's unlikely a hostile work environment. It's just you don't like to work Saturdays. A manager holding someone accountable. I've had employees come forward and say, well, it's a hostile work environment. She won't quit harping at me about my stats, like a salesperson. And it's like, okay, I'll say to the employee, well, talk to me about that. What are they doing? Well, every day she wants to meet with me and review, you know, the number of calls I made that day and the number of leads that I got that day. And it just stresses me out, and it's hostile. I can't take it. And it's like, well, oh, are you like, does she only meet with you? Well, no, she meets with everybody. She's the boss. Every day you have to go to her and you have to tell her how many calls you made and how many people you talked to. And it's just, I find it stressful. Well, if that's the job and you work in inside sales and they've said, you know, you need to make a certain number of calls, that's a job situation, not a hostile work environment, if that makes sense. So it can be a very, very fine line between a hostile work environment and a truly just part of the job. So using that last example, I would say, think about if you're wondering to yourself, do I have a hostile work environment situation, or do I just not like my boss? Or do I not like the job that I have anymore? Think about, are you being singled out? Is what is happening to you work related or non-work related? So if I went into that last example and I was the only person the boss was calling into the office every day, I was the only person who was being, you know, micromanaged around my numbers, we may be able to dig in there and see if it's hostile work environment, but I would ask, is there a performance issue? Have you been put on a performance plan? Are they targeting your performance because they're telling you you're not meeting goals? So there's ways to work through it, all of these issues. Just know that before you seek out a lawyer for any of these matters, I think there's certainly plenty in the Mount Holyoke community, an HR person who can walk you through and give you a good idea of what's happening and how hearing out your story and understanding where your rights fall is typically the better first step. First of all, a lawyer is really expensive. And second of all, a lawyer typically isn't going to take on a discrimination case unless there's some basis of finding that they feel like they've got somewhere to go. So talking with an experienced human resource person who can help you is probably the best way to go. So I know I didn't leave a ton of time for questions, but I'm happy to take them as long as any of you have them. And then also, as I said, find me my name on both Facebook and LinkedIn is exactly as it is here. So I would love to connect with anybody who, would like to talk about any of these topics further. And thanks so much for your time and for logging in today.
Maria, thanks so much for being with us and for sharing the robust wisdom that you have on this topic. It's really appreciated. So yeah, just reiterating, if you have questions, feel free to throw them in the chat if there's something specific that you wanted to raise. I'm also going to throw back in there the site where you can find recordings of these webinars. I'll drop that in there. So I see a question. Is it possible for multiple employees to experience a hostile work environment with the same employer or department, or called something else?
No, it could be a group of people. So it is, and I see there's another alum there that is saying they can also help out with questions. And I think it's great to have a sounding board. No, it can definitely be a group of people. So sometimes maybe it could be and this is, I hate this word, but it's what they call it in our line of work, like a class of people. So let's say, like I had this come up with one of my clients that were in home health care, and there was a group of like the home health aides that they really felt like they were being treated differently as a group, like because of their title. And it also, in that particular organization, that group was of a similar race. And so they really felt like, we're the kind of the lowest on the totem pole, and we're all of one race while ownership is of another race. And we really feel like a hostile work environment is being created here. So absolutely, it could be a hostile work environment towards a work group. That can definitely be the case.
Awesome, thanks so much. And while if there are other specific questions, I'm just going to also drop again the link to our Gates Connections platform is a good space to follow up on some of the topics or reach out to alums. Just going to drop that link in here again.
Well, I thank everybody for jumping on. It was really good to be with all of you. And I talk about these topics so much that I'm hopeful that it can help somebody with a current situation that they're working through, or connect with others, other HR professionals here as well. We have so many great communities out there, and I'm going to jump on the Gates community and get logged into that as well today, because I know many of us use Facebook for that. So I'm glad that there's another platform as well. Sometimes it's better for my mental health to stay off Facebook. So I will definitely check the Gates community and just encourage you to understand your rights. That's what I'll leave with. Do a little research, reach out and find somebody, and make sure that you understand how these laws work for you, because work is typically a huge part of our life, and it's no place to be miserable. I tell that to people all the time. Work is no place to be miserable. So find work that you love. So thank you everybody here, and I look forward to connecting with you on social media and on the Gates.
Awesome. Thanks so much, Maria. Wishing everybody a good day, and we'll close it out there. Have a good one, everyone.
Thank you. Bye-bye.